May be permitted to
Please not
mention,
be
my lord,
mentioning
key
them.
matters, my lord. These are pending before this court, my lord, for quite a long time, my lord.
Today is not the mentioning them, Mr. Come back on Thursday with notice. Yes, call the list.
But I am for the petitioner, my lord, in this matter, my lord.
My lord,
It's a direction to file an affidavit by the person who claimed that he had taken the money. There was an allegation which was coming from the audited account report of the Boshirat municipality. My lord,
You are
it
for
was
municipality.
no, my lord, I am for municipality led by Mr. Amita Bose. I'm praying for,
The petitioner.
petition. I am for the petitioner, my lord.
my lord, I'm praying for short Passover, my lord.
My lord, if there is an affidavit which has come, my lord, which shows the dangerous affairs in respect of Boshirat municipality. My lord, it says
But kindly looks into your lordship's order of 29 June.
Give us 2 minutes time.
ভদ্রলোক কোথায় গেল? আপনি থাকুন।
অমিতাভ বোধহয় একদিকে হয় কি অসুবিধা নেই না দাঁড়া চল
Jungle cutting and trail.
ঠিক আছে এখানে এই দুটো পিঠ এখানে আছে হ্যাঁ ফটোগুলো এটা কি আছে
Who is for Probir Chatterjee? You are appearing.
an affidavit has been
Affidavit of
served
report,
by the
as your lordship directed.
where he
That's fine.
concedes that this was given to him in his account and his wife's account.
You have got the copy.
I got
I
the
have prepared an affidavit in terms of your lordship's direction. Now, my lord, the affidavit in terms of your lordship's direction, my lord.
Refund the money, Mr. Bhattacharya.
My lord, I'm clear this, my lord. These are the, my lord, the master roll and the labor register, where this payment has been made about the allegation of 70
this is completely contrary to the rules.
72 lakhs payment was made
through the labor and wages through the accounts of my lord, that Probir Chatterjee. We have the records of that master roll. Our auditor put some observation over it, and it is under the scrutiny of my lord before the, my lord, the constant account section, my lord.
of your municipality.
Not my municipality, state, my lord, AG
Bengal.
Bengal.
Pardon?
My lord, this
It has been
Our-
sent for auditing to whom?
our auditor put some observation
Right.
over some expenditure and, my lord, the balance sheet, and, my lord, with that observation we have forwarded to the AG Bengal.
But what step have you taken against this person? He's still in.
My lord, no. In 2025 he retired.
Retired.
And this EO
Well,
was not at the time of, my lord, this period he was the EO. Rather, my learned friend client was the ex-councillor of that municipality, just president after that, my lord, this my lord, year.
well, in the
My lord, this
paragraph
is the
20,
situation, my lord, and, my lord, irregularities is there. My lord, so far this EO find from the record, he is not the eyewitness from the record. Some irregularities is there, but the then board of councillors, as per their direction, as per my affidavit, my lord, considering the urgency, my lord, without following the, my lord, the tender process, anything, my lord, they have appointed this thing. This has been irregular. They are made caution.
if your lordship kindly take up his affidavit filed by Mr. Bhattacharya's client,
What is your prayer in the writ petition?
my lord, it's my prayer is to transfer the entire investigation, and my lord, I have also prayed for the conduct of the my lord, here by the first prayer, my lord, is that issue respondent authority entrust the investigation to the CBI, vigilance, and my lord, I have also prayed for the resolution, lease deeds, tender documents, all this executed by the Boshirat municipalities. My lord, there are the documents which shows that Taki municipality, that documents, there are the documents which will show that, my lord, there was lot of irregularities, except the, if I,
You lodged any complaint against this person
My lord,
after ascertaining this?
my lord, in departmental and inquiry,
Your entire board was involved then.
my lord, these,
entire board was involved.
Mr. Chatterjee, if you continue disturbing, we will release the matter.
my
Let
lord,
us hear him. Yes.
Yes, my lord. We are the present board, my lord, are trying to after raising this issue, they are find out the my lord. They are trying to my lord make a proceedings to where is what and what is about. My lord, now the my lord the office report and what is the documents which reveals that there is a master roll and labor register. We have to compare with this that the my lord with that 72 lakhs, so that my lord, if any discrepancy found, so we can take action against him.
may I make a
Since he retired in 2025, now this issue has been came up to us. My lord, we are trying to, my lord, compare it with,
Yes,
with
what
our
is
master.
your stand?
Yes.
First, at the outset, I tender
Where
unqualified.
is your affidavit?
Well, an unqualified apology, my affidavit has been affirmed only day before yesterday. We have served. It is, slightly beyond time prescribed by your lordship's order, Your lordship wanted me to file an affidavit, within 7 days from date of receipt of copy of the writ petition, which I received, sometime around 11th of July. I ought to have filed the affidavit by 18. It is slightly belated.
You have affirmed today.
Yes, no, I have served.
It's served, my lord.
Now, what is your stand?
And I'm giving.
Now,
I'll get a copy here.
May I submit one thing, my lord?
you're coming back. Like, in short, tell us what
Please
is your
see
stand?
page 26 of the affidavit.
Yes.
I have annexed it.
In pursuance of notification number 337 dated 22/4/2010, Sri Probir Chattopadhyay, LDC, of municipality is hereby engaged as paymaster for wage payment of West Bengal Urban Employee Scheme. Payment of wages to be done by the paymaster in presence of respective councillors. The fund has been transferred from municipal fund to the bank account of Sri Chattopadhyay. He will be maintaining a register of mandates generation under such scheme. Now, my lord, please fall back to the affidavit. Please fall back to the affidavit. Please kindly come to page 4.
ও কি ও তো বলছে আমার পারমিশন দিয়েছে।
পারমিশন দিলি তো পারমিশন তো দিতে পারে না তো যা
My lord, we are not getting the copy. Can you ask him to supply me a copy so that I can tally it with my office?
Please,
Where is this notification? This order is being by the chairman refers to a notification of 2010
my lord, I have handed over.
issued on 3rd of
I
January.
have handed over. My lord, I have handed over.
Why didn't you annex
My lord,
it?
it was not with me. It has just come. I have been able to lay my hands on, my lord.
শুদ্ধ একবার দাও আমি তোকে দিয়ে দিচ্ছি
অফিসাররা পার্সোনাল
My lord, please see.
অ্যাকাউন্টে রাখতো
একটা কপি দাও না
ভাই একটুখানি ওয়েট করো, দিচ্ছি, সব দিয়ে দেবো।
যদি করে
কপি আছে?
একটু করো, তুমি করো না। করো না কপি দাও নিয়ে যাও।
Kindly see.
Board of Directors.
পার্সোনাল অ্যাকাউন্ট অফ এনি এমপ্লয়িজ পারমিশিবল
My lord, that is for the municipality to answer. Board of, my lord, I was an employee. I am telling your lordship what happened thereafter. Kindly seize, my lord, 2-3 paragraphs.
Oh, you are very innocent. You
No, I
don't-
am not saying
Well,
this was, my
What
lord, I may, my lord, at best say I am a victim of circumstances. My lord, please see, my lord, what I have stated. I may be incorrect, my lord, not 72 lakhs. Total 75 lakhs and odd, my lord, was transferred through, my lord, RTGS, my lord, from the treasury. I have disclosed all these documents here. My lord, please see, kindly see, my lord, 2-3 pages, 2-3 paragraphs, I'll stop. 2-3 paragraphs.
Para 20 he takes the name of the chairman.
And my lord, whatever has been done, and every record is available.
Member for board কাউকে তো the then board of councillors.
Yes, my lord. Paragraph 20
Lord,
he has taken.
Kindly
Sorry,
permit me 2 minutes. Show your lordship. Annexion R3 is pleaded, my lord. Annexion R3, I invited your lordship's attention, my lord, page 26.
What will you show? You will show that the money was given in my account at the dictate of the board of councillors.
No, I will show that it is not nearly 72 lakhs. I have disclosed the exact figure, and I have also said that, my lord, beyond the figure, my lord, an amount extra was paid from my account. That is also I have disclosed. And my lord, every detail is available, my lord, from the documents which I have annexed, my lord, the thick papers, my lord, which shows, my lord, that the relevant employees, my lord, they took the money. My lord, 120, my lord, in terms of the scheme, 120 is the wage structure. My lord, please see.
It's an old thing. The employee would keep the amount, government amount in the account. 1 month delay, the interest
Well,
coming there
My lord,
from.
what has happened? What has happened is it is not for an entire period. It is only for 3 months that this money entered, not for the entire period. Well, I have explained it. I mean, my lord,
well, my lord,
whatever
if your
it is
lordship kindly come to paragraph 20.
at page 26 has not been withdrawn by anyone till date, to the best of my knowledge. To the best of my knowledge, it has not been withdrawn. Will not please see paragraph Roman 4 at page 4.
Official money, the person authorized will pass an order from treasury, it will go.
That should
That
be
should be
the
the system.
that should be the process. That is
And
the
it
process.
is going on, yes.
And will not
Well, there is a rule 8 of the West Bengal Municipal Finance and Accounting Rules 1999.
পরে দে, Xerox করে দে। Look, 16 নম্বর মানে কি? iPad নে না। iPad নিয়ে না। ইয়েতে নিয়ে নে। PDF পাঠিয়ে দিচ্ছি।
আমার সঙ্গে তো অসুবিধা সঙ্গে আছে দাদা
প্রাইভেট অ্যাকাউন্টে এইটুকুনি জানি
অনেক কিছু আছে।
এখনো ওয়ারেন্টি ঘুরে বেড়াচ্ছে
টাকাটা তো দিতেই হবে একটা দিতে হবে ভালো যদি
To indicate two things, my lord. The affidavit filed by my learned senior friend Mr. Bhattacharya's client, my lord. If your lordship take up paragraph 20 of that affidavit. In paragraph 20, he deposed, the deponent said that it is pertinent to mention that at the relevant point of the time, the chairman had a close working relationship with the then sub-assistant engineer, Mr. Dipankar Das, and accountant in charge, Mr. Shubhro Kumar Das, and the said officers, along with the executive officer and the finance officer, repeatedly represented the funds allotted under the Urban Wage Employment Scheme were required to be utilized within the stipulated time, and that they delay or lapse in disbursement would result in the funds being returned. I was subjected to persistent intimidation, coercion, and undue pressure. I was threatened with serious consequences, including that my career and the service would be adversely affected if I did not comply. Being under such fear and pressure, I ultimately agreed to act in accordance with their direction. Thereafter, funds were transferred from Treasury to my designated bank account from time to time, and I disbursed the wages strictly through my master rules in presence of the concerned councillors and other municipal officials in accordance with the directions of the competent authorities. Thereafter, 21, my lord. Thereafter, I regularly disbursed wages to the laborers through the master rolls in presence of the concerned councillors and the municipal officials. The master rolls as well as the payment registers bear the signatures of the concerned councillors, and in several cases, the signatures of the chairman and the vice chairman also available. The finance officer, the executive officer, and other officials were present during the such disbursement. Every amount received by in my account was duly utilized for payment of wages in the accordance with the official directions. I did not retain or appropriate any part of the municipal funds. Thereafter, 23 is dangerous, my lord. I continued to discharge my duties in the municipality until my retirement on 31st October 2025. After my retirement, an inquiry has been initiated pursuant to the order dated 12th November 2025 issued by the Director of Local Bodies Government of West Bengal in relation to the expenditure of approximately 72.72 lakhs. I duly participated. Now, Lordship, apart from that, I want to indicate one provision. That is Rule 8 of the West Bengal Municipal Finance and Accounting Rules
For the state.
1999.
Who is for the state?
State Lordship, led by Mr. Debashish Basu in this matter.
Led by?
Mr. Debashish Basu. Debashish Basu.
Where is he?
Lordship, he is on the way, Lordship. Lordship, in this matter, we do not have any instruction as regard to that from the state, Lordship.
Take the mic. What you are submitting?
Lordship, in regard to this matter, we do not have any instruction. Lordship, praying for time to take instruction in this matter, Lordship.
My lord, so far, last order, as per direction of your lordship, DLV has my lord, gone to our municipality. They took all the documents.
Who has gone?
DLV, authorities of DLV, Director of
DLV,
Local Bodies.
Director of Local
Director of
Local
Local
Bodies.
Bodies. As per your lordship direction. Last occasion, Mr. K. Apia কি নাম যেন আমাদের?
Debashish Basu, Mr. Basu.
No, Lordship. We have just now interested in this.
Mr. Ajit Mishra was appeared last occasion.
Yes, last occasion.
Does the court start at 11 o'clock? Your seniors are not here?
Your Lordship, we came to know in the morning that
Who is appearing for the state then?
Lordship, I am appearing for this state, Lordship.
You gave it to Mr. Mishra?
Yes, Ajit Kumar Mishra. Mara, kindly see last date orders.
Lordship,
Is
lastly,
been
it was
recorded.
entrusted to us by the Ailer
Handed over to you?
No, Lordship.
Then have you got copy of the writ petition?
Yes, just yesterday we have got the writ petition. So, Lordship, praying for time to take instruction.
হচ্ছে তো সমস্যা তো।
Your Lordship, Mr. Mishra will talk to GP regarding.
others which I can demonstrate today that
pursuant to the
what
earlier
are the There were the earlier order
Now,
passed by this court.
Which book you are
These have been complied by us. This is the report.
Panchayat.
Huh?
Bengal municipal law.
What is that you are handing over?
The affidavit of service for compliance of the earlier orders.
Affidavit of service as file be kept on.
Well, there was a complete bar under this rule that no money could be transferred to the private accounts.
That is it.
Still, this is
I cannot leave Milord because he will not stop.
Yes, call the next matter.
no. I can go. That cannot stop me in that fashion. No.
Yes, item number 2, item number 2.
In this matter, I will
Your Lordship, pursuant to your Lordship's direction, we are filing our affidavit. We have served the other side.
No copy has been served.
আপনার যে অ্যাডভোকেট অন রেকর্ড আছে ওকে সার্ভিস করা হয়েছে
All লিখে দিচ্ছে তোমার জন্য দাঁড়িয়ে থাকবে
ক্যান দিতে এসেছিল যে
My lord, I file an application for addition of party in this matter, my lord.
আপনি
He also appearing in the list, my lord.
Your Lordship, I'm handing over the copy right now. In terms of your Lordship's last direction, there was a direction to file affidavit placing on record regarding the construction of the road. There was an allegation that there has been a misappropriation of fund for under road construction, and the road which was required.
Where is it? Where is it?
Your Lordship, I filed the affidavit today.
Dekhi.
Affidavit.
No copy has been served to me.
You have not been given a copy.
Your Lordship, I'm handing over the copy. I've served it
My lord,
on
it was
email.
Directed only to file the report, not affidavit in opposition.
Yes, what is your stand there?
Your Lordship, if your Lordship sees page number 17, there are two roads. The bottom one is the one which is being constructed by the PWD department.
Blue one.
Blue one.
Yes.
And it was constructed back in 2020 itself. The tenders which he is alleging that it misappropriation of fund and other things. 2020 itself it was allotted, and thereafter within time it was constructed.
So which is the road he is speaking of?
The one which is in red, the top one, your Lordship.
This is a Google map you have provided.
Your Lordship, to show the map,
Where is your tender order?
Tender documents are before that, your Lordship.
From which document we would be able to understand?
Your Lordship, page 7 is the entire document which shows.
This is a general administrative approval given.
Your Lordship, page 16 has the kilometer-wise road details. Page 16.
Page 16.
The first one, name of the work. The completion, so it is a completion certificate of the work which was done.
Narazol Dashpur Road from 8 km to 14.5. Yes, but that part of it was done.
The complete road was constructed. This is the
His allegation was
allegation is pertaining to the another road.
Pertaining to no. His allegation was that from Dashpur to Narazol,
Yes.
There is a distance of 14 kilometers.
Yes.
KMP. And the concrete road was constructed. Thereafter, PWD entrusted widening and repairing of 8 kmp to 14.5 kmp. However, the part from 12 kmp to 14.5 kmp was left out. It was neither repaired nor widened. This is their case. Now, from which paragraph or document of your affidavit we can come to learn?
Your Lordship, in the project itself, it says what is the starting point and the ending point of the road. Completion certificate, the top one, Your Lordship.
8 kmt to 14.5 kmp. Your case that the entire road has been constructed.
Your Lordship, back in 2023 itself, it was completed. My learned friend allegation is pertaining to the other road. He is wanting widening and with the red mark road.
He's not saying other road. He's saying that Narazol to Dashpur.
Yes. Get portulars.
His allegation is that pertaining to this Narazul to Daspur road.
That has been done, Your Lordship.
Where from we can
This is the completion certificate by which in
Completion
2023 it was done.
The page number 10, Narazul to Daspur, 8 km to 14.50 km, widening and strengthening work under Medinapur Highway Division. That work. Now
50
completion certificate, page 16.
দেখো দেখো পেজ 16
Yes, name of work.
Same.
হ্যাঁ, 15 লাখ টাকা ইয়ে হলো। Tender amount
13 কোটি।
estimated amount 16 lakhs, 16 crores.
16 crores.
আর
Final bill value 13 crores. Widening and strengthening work comprising of such and such.
টোটাল প্রজেক্ট কস্ট ধরা হয়েছিল 18 কোটি করে।
কমপ্লিট হয়ে গিয়ে এখন
No, my lord, not.
Get you these on the picture. এই যে come to page 18.
80, হ্যাঁ।
এটা আরেকজনের ইয়েতে দিয়ে গেছিল। Reveals that from the PWD authority, it was the complaint was sent to the special acquisition land acquisition
Your Lordship,
officer.
certain RTI was made by the petitioners and a complaint was filed. Accordingly, a reply was filed. That is page number 18, Your Lordship.
Page number 18 is by a letter you have forwarded it for a
This is
inquiry.
2026, Your Lordship.
Yes,
The work was completed back in 2023 itself.
in 2026, your PWD department has forwarded it to special land acquisition officer with a prayer that you conduct an inquiry and tell us
Your Lordship.
what had been the fate of that.
Your Lordship, this was sent on 9th of June 2026.
So that is after our order,
Your Lordship, no, before
Oh,
just prior to our order.
Your Lordship.
Now, who is the Shubhendu Datto?
I am for the petition.
You are Shubhendu Datto.
Yes.
So why didn't you disclose that they have given a right to information reply to you at
No,
page
my
20?
lord, that is not correct. They are misleading the code. My lord, kindly see for a moment.
You kindly see. You
Page
kindly
20.
see.
এটা হয়নি
Page
তো।
23 of my
জায়গা
lead
থেকে
application.
বোঝা যাচ্ছে।
What you are showing?
My lord, right hand side, my lord.
Page.
Page 23 of my
Of-
lead application. The approved road. Up to 12 km. The lordship got it. Serial number 12. Right hand side.
Page 23
23.
of your
Lead application.
It's a KDS.
yes.
Serial number 12, Suronarayanpur. Up to Suronarayanpur, they have completed. That means 12 km. Then they have left Dharampur, Samsundapur, Daspur. 2.5 kilometers they have left. Kindly see the photograph, my lord, for a moment.
দেখাও দেখাও দেখতে পাচ্ছ। ওই পেজটা একবার পড়ো
দেখাচ্ছি।
ওই পেজটা একবার পড়ো।
You come to page 16.
of this writ petition,
of your affidavit.
Your Lordship.
What is name of the work? Najol Daspur Road, 8 km to 14.50 km. Now, your remarks. Work has been completed satisfactorily. Your remarks. Date 16th May 2023. Okay. Now we come to page 18. Date 9th June 2026.
Yes.
Here you have stated that question have subsequently arisen regarding PCS alignment of the road stage from Patasa. And its corresponding road presently in existence and maintained as Narajol Daspur Road under PWD Roads Directorate. So determination issue. That means this portion, regarding this portion, some question regarding acquisition of lands are involved.
With full tollers.
And hence this portion has not been done.
Your Lordship,
Although you have shown the entire work has been completed
in
satisfactorily.
2023's completion certificate was given. I cannot deny what is on record. Your Lordship, pursuant to his complaints, even the department has raised it, whether land acquisition department had completed the acquisition process for the remaining portion or not, as he is relying upon the page 23 of his writ petition.
Already acquired, subsequently handed over to the PWD. They have constructed road, time to time they have maintaining. But 2020, they have diverted. Left the remaining part from 12 km to 14.5 km. The photograph itself clearly shows this to 32 and onwards.
Does not follow. Page 20 টা দেখো না। Page 20 প্যারাগ্রাফ 1 এ ওদের রিপ্লাইটাই এটা। সো কে ক্ল্যারিফাই করবে 3 বছর 6 বছর? প্যারাগ্রাফ 1 এ পরিষ্কার বলছে it does not include falling from Peter Narazol to Daspur in accordance with
Puro Narayanpur, such and Dharampur does not fall within the jurisdiction of PWD road.
Yes.
But whether from Narajol to Daspur, this Moja comes
That's put to Narajol, page 23.
Puro Narayanpur,
Yes. Via.
With 87, 89.
Sematoni, Dharampur, Samsundarpur.
কে ডিসাইড করে হতে সব অ্যাকচুয়াল ইস্যু আমরা রিটে কি ডিসাইড অ্যালাউ করে দাও ওকে রিপ্লাই দিতে পারে মামলা শুনে
So you file reply.
My lord, in this matter, I
My lord, kindly see for a moment, page 32 for a moment. Page
Mr. Shimu, we are not, these are factual issues.
What, my lord? the
Factual
whole
issues,
issue
High
should be
Court
clear.
cannot go in. Your
Not
contention
clearly, they
is
have
part
left
of,
up to Suranananpur, they have completed.
that
Then-
is your allegation.
Yes.
They are working on the allegation. But they are saying that the road which you are pointing out is not the road for which the contract was given. There is a dispute.
Yes.
So who can resolve the
So,
dispute?
my lord, what
High
happened?
Court will go into and find whether your road is
Satellite
there.
map indicated the how many roads are there situated, not indicated all the roads
This
maintained
is
by
a
the PWD.
discretionary jurisdiction,
Some
Mr.
road, my
Shimu.
lord, satellite, according to satellite map, some road maintained by the PWD, some road maintained by the Jila Parishad, some road maintained by the local board. That is not correct standpoint. Till now, the road is not repairing. Road is page 34 and onwards, my lord, kindly see. Large number of people, they are suffering, my
So
lord.
what were you doing for 3 years?
My lord, we are repeatedly
What
knocking the door of the
Take
authority.
the representation after 3
No,
years.
my lord, kindly, my humble prayer, my lord, kindly
Come with
appoint,
your reply,
my lord,
let us see.
kindly appoint any special officer own cost by the petitioner, whether they have.
You come with your reply, then we will consider.
my lord, in this matter, my lord, I file an application for addition of party. We are the most affected person because, my lord, they bifurcated the land from the original, bifurcated the road from original road by taking the land of.
Where are you sleeping? After he has come, you
No,
have
no, no.
started
I made an application to the authority. I came from there that writ petition is pending. That's why I filed this application, my lord. I made an representation to the authority.
Your presence is not required. We are going into what will you say? Your presence is required.
That is our right already.
My lord,
That means our 3 years. That means that my right cannot.
authority has tried.
7 hour land they have acquired. Subsequent constructed road. They have time to time maintaining. But in the year 2000, they have suddenly diverted, bifurcated.
This
Approved
diversion,
left to road.
this diversion is your allegation. High Court will go to the site and find out.
No, my lord,
What
only
happened,
direct,
when was the
according to map, my lord, and according to proposal, only constructed, only completed the work of remaining part. Maui allegation, my lord, nothing else.
So
We are not praying for new construction. We are not nothing else, only remaining part. Large our land acquired. We are deprived from our benefit.
say addition of particular
Yet, my lord. Trying to, my lord. My
Thank you. So new act will come, they will take under new act.
Where is that encroachment you have stated? Which paragraph?
paragraph 8, my lord, in my application.
এই যে আপনি ওইটাই বলে দাও। You will find your yes. Next.
Okay. Item number 3, Malad, we beg to appear on behalf of the petitioner, Malad, the commissioner. Malad, actually, erstwhile Mr. Kaushik Kanti Maiti, Malad, who was doing the matter, he expired.
Pardon?
Malad, erstwhile, Malad, Mr. Kaushik Kanti Maiti was doing the matter.
Anything remains in the matter?
Malad, we also do not know because we do not have the cause papers.
So you have instruction to appear now?
Yes, Malad. Do we take a certified copy within 7 days? Thereafter, your lordship fixes the matter.
Certified
Copy of the pleadings. We do not have. The department also do not have.
your engagement is
Yes,
there,
ma'am.
Mr. Bhatt?
Yes, ma'am.
See, now, who has expired, Mr. Banerjee?
My lord, Kaushik Kante Maiti. He was the senior counsel of the department. Now, Oishorjo Rajusri is the junior counsel.
Oh, I see.
So the cost papers were entirely in his chamber. We also requested his brother to find it out, but
Anything, it is a matter of 2021.
yes, my lord.
And your writ petition, the
My lord, let us go through it, my lord, any day, my lord. We will assist your lordship, my lord.
board. No one appears. Records reveal that no one appeared on ওইটাই আছে বলে সেম yes.
Lordship, I am appearing for the petitioner. Lordship, passed an order efficiency test and medical. I hope that the petitioner had
Seven. Yes.
7, I am for the appellant ballot. Ballot, the service could not be affected. The 85 respondents are there. And
What was the order of the tribunal?
order of the tribunal was that I have to regularize the casual laborers with a retrospective effect and give pension.
No contempt filed?
No contempt filed as yet, as far my knowledge goes, my lord.
This is an order of
The Central Administrative Tribunal, my lord.
2025.
Yes, my lord. The voluminous copy, my lord, 85 persons are to be served. So the department has not contacted even. That's the whole problem. I have to do everything.
It is better to accept the order.
85 with a retrospective effect. They have retired. Thereafter, they have filed the case.
No, consider justified. Tribunal found that.
And a similar issue, your lordship knows, a similar issue is pending before the Honorable Supreme Court, my lord, on the same issue that is pending. For I mentioned when your lordship was in court number 11, my lord. That is still pending, my lord.
Which is that matter?
I have that.
84.
I have only one copy, my lord. This is pending, my lord, on the self-same issue, my lord.
We will how we will understand that,
my lord,
Mr. Panda?
Yes, I shall on the next date. I shall produce, my lord.
Mr. Panda, learned advocate, appearing
You can
from the
I appear. I beg to appear on behalf of the petitioner. My lord, in this matter, I shall not take your lordship to the merit of the matter, but only to the point of jurisdiction, my lord. My lord, the matter relates to the impugned order is the order of review, and the original order has been merged with the order of the review. The original order is at page 164, passed by the learned tribunal. Tribunal right me. Direct High Court. It is relating to my lord. I am just questioning the jurisdiction of the single member bench of the tribunal. The matter relates to selection for the post of the law assistant through general departmental competitive examination. And the question is whether the learned administrative member.
where you have argued.
No, that point has not been argued, my lord.
Oh, the point has been made up now after you were engaged.
Well, and because if the
after or original application review after dismissal, suddenly now you see
Well, Lordship,
parent in the review, did you take a ground to that?
no, that
Then
one was not.
why should we allow you to go
Well,
to that?
Lordship, kindly say,
No, we are not required to consider that. Show us your review ground was
No, there is no such ground.
Then sorry, sir, we cannot entertain your
Lordship, kindly see, as per Administrative Tribunal Act, that point cannot be.
It is constructive res judicata. You have not taken the point.
Lordship, kindly see.
Show us one ground in the review.
My
Let us
lord,
not quarrel over this issue.
My lord, if they, even if it is not raised, if it hits the jurisdiction, that order is void of
That point you could have taken prior to preference of the review before the tribunal.
My lord,
this is nothing but wastage of time.
My lord, otherwise, my lord, because my lord, if the jurisdiction point
Come
goes.
to paragraph 10 of the order. What is the order? Main order, what is that order? Seeking options for consideration, we can pose the applicant submit.
Thereafter, the response to the.
You did not appear in the.
No. The point is that two selection post. There was two selection, and.
Sir, read the order, then make submission. You have no case. That is why you started by saying jurisdictional error. Read paragraph 10.
Lordship, kindly see one thing. Lordship, kindly see.
How will you remedy the situation? Tell us.
My lord.
You participated in the exam, you did not secure the marks. What will they do? Even if your argument is accepted, then we have to send it for reconsideration.
My lord,
so how will you damage your repair your damage?
There are two selections, one in 2013 and one in 2016.
Read paragraph 10.
So far as paragraph 10 is concerned, it is about 2016 selection. And in 2013 selection, the proper opportunity has not been given. That's why two original applications were filed. Lordship, kindly see the number at page 164. It is on one at 2014 and one in 2019. There is two selection.
Two order in review.
And both the original application had analogously.
So if there were two selections, that was first one was 2013.
And
your original application was filed in
2014.
So where is the two selection in your prayer? Legal of depriving the by not informing him the date of examination.
That is in the first selection.
Then when was the second selection?
Second selection in 2016.
So where is that case you have made out in your review petition? Sir, you have to go through the brief. Don't give extempore speeches here.
No. My lord, only I am here.
Show us that 2013 and 16 two selection process where you have stated.
No index has been prepared.
Kindly give it time. I can prepare the index.
So you should have said that at the inception. You are not prepared with the matter.
My lord, I am prepared on this point, on the point of jurisdiction, my lord.
And there should be two volumes in this.
Inclined to proceed with the matter today, then proceed. We will consider.
No index, no list of dates.
Let the jurisdiction point be kept open. I shall argue on this point.
Certainly not. You argue on merits of the matter.
Yes.
Well, let the jurisdiction point be. Otherwise, my lord, the entire thing goes. Because my lord, jurisdiction is the root of the cause. And lordship, there are several judgments of this court on this point.
কেস কি ও হচ্ছে 13 সালে যে পরীক্ষা হয়ে গেছে ডেট হয়ে গেছে সেটা জানতে পারি পরে একটা রিটেন
বলছে দুটো সিলেকশন প্রসেস
হ্যাঁ এটা 13 সালের পরীক্ষাটাও জানতেই পারিনি ডেট
was given opportunity. He was given opportunity.
And lordship, there are several judgments of this court. Also, kindly consider the judgment.
You are not ready with the facts. Kindly consider the judgment. We are asking questions. You are not in a position to answer those.
My lord, kindly appreciate. I am ready on the point that it is on the jurisdiction point.
We will hear jurisdiction. Tell us the facts.
My lord, it is relating to the selection of
Show us.
law assistant. Lordship, kindly see the list of dates.
No list of dates.
List of 2 years.
Firstly,
2 weeks. Yes. Party learned advocates.
Now,
Yes.
but the short point is, my lord, the in connection with the charge memorandum dated 14th November 2018, the inquiry officer was appointed on 30th April 2019. But the appointment of the inquiry officer is bad in law initially, and the subsequent actions of the inquiry officer is biased. That's the main allegation. So why the appointment is bad in law? The criteria for appointment of the
Yes.
inquiry officer age should be 70 years, not more than 70 years at the time of appointment. After crossing the prescribed age limit, he was appointed as an inquiry officer.
17 years?
70 years. 70.
Oh,
inquiry officer's age should be the 70 years at the time of his appointment.
this was the sole ground. This was your ground.
This is the primary ground.
Was the paragraph where the tribunal has dealt with that issue.
Well, that is at, I'm showing it to your lordship, my lord. Paragraph 18.
Paragraph 18.
Paragraph 18, internal page 14 of the said judgment, my lord. The applicant has contended that the departmental inquiry initiated against him suffers from a major infirmity insofar as the inquiry officer, namely Sri L.C. Mojumdar, who is a retired officer, was above the age of 70 years on his date of appointment as inquiry officer. From the records, it is established that the date of birth of Sri L.C. Mojumdar, inquiry officer, is 1st July 1948, and that as such he was above age of 70 years on the date on which he was appointed as an inquiry officer in the instant disciplinary proceedings. The respondents have, however, contended that a one-time exemption was obtained from the Railway Board for the appointment of Sri L.C. Mojumdar as an inquiry officer in the instant departmental inquiry and have placed material in support of their contention in this regard.
Yes.
The learned tribunal, let them show the material.
Show us the provision by which it was 70 years more, which is page?
That is at page 273. That is volume 1, 273.
Yes,
Volume 1.
273.
273. Volume 1 to 270. No. No. 1/3. Sorry. 273 volume 2. 273 is at volume 2.
Tenders at
Tender na kore local market.
no, accepted tenders. Charge to
First clause.
accepted the offer of lowest suitable tender. Weeks.
এটা একটু সরাও ওটা।
Linear DA. Page
273.
273.
Volume 2.
Good letter. এখানে হচ্ছে এই অ্যালিগেশনটা তুলবে।
This is in connection with the
the order of his appointment. না এটার বক্তব্য সেটা করে কারণ appointed হলে তখন participate করেছে
it starts from 273.
273
is the relevant page.
Show us that page.
Well, 273.
Which
A1, the first annexure 273 page. Annexure 2 of the board's letter 2010 so dated 7/10/2015, terms and conditions for appointment of inquiry officers to conduct departmental inquiry under Railway Service Discipline and Appeal Rules 1968 in cases arising out of the vigilance investigations against the railway servants. Specific terms and conditions from retired inquiry officers. A1, the inquiry officer should not be more than 70 years of age at the on the first day of July of the year of his empanelment. His date of birth is, my lord, 1st July 1948.
No, that is admitted. Tribunal has said that yes, he was above 70.
Right. That is the violation of rules.
Then which this he got a one-time relaxation on view of the board?
My answer is no.
No, your answer will be no, but what document did they place?
Let them place.
You place, it is your
No
child.
document has been placed.
No document.
Yes, no document. Nothing.
Any other point you want to argue?
Yes.
What?
The subsequent allegation, my lord, the biasness. What the biasness is, my lord, that is your lordship, my lord, kindly have a look. The biased application, my lord, should be placed before the
order is court করেছে
can be there.
My lord, those document was produced the time of my lord inquiry officer. Was copy was given to the petitioner also. At the time of hearing before the tribunal, that document was also my lord.
But you did not annex it in your reply. You did everything, but did not annex that in the reply.
My lord, it is my lord. It's fact. That was not annexed, but in the reply that was very specifically that statement.
No, no, you have not said that.
But my lord,
Reply, you have failed to substantiate that point. You said one time exception was given.
Yes.
No record was produced.
That was produced at the before the tribunal.
Where from we will find that it was produced and this was taken into
And
consideration.
my lord, before the inquiry officer by giving copy
We
to
are asking you a question, sir. You tell us that this is the page where we have said. You have said nowhere.
in my reply that statement is there.
No, reply statement is it has got the approval of
Yes,
the
yes, yes.
railway board for expeditious inquiry as a one-time relaxation. This is your reply.
Yes, that is the one-time relaxation, my lord, the documents.
Mr. Ghosh, call us spade a spade. Don't take innuendos that I
No, my
will
lord,
go this way, that
I am not.
we are putting a question to you. You are showing us that paragraph, which admittedly shows there is no explanation.
My lord, for a moment, my lord, kindly.
Meet the question of the court, sir. Today we will not believe that this letter was produced before the tribunal and it was considered.
My lord, my instruction is, my lord, that document was produced before the tribunal also, my lord.
You have been given a wrong instruction. You should have hauled up your officer. You should have hauled up your officer.
কপিটা আমায় দিন না।
Later.
Rightful, your lordship. My lord, the subject major penalty DR action against Sri Ajay Kumar Daden, senior DMM, ACCR, NGP, now senior EDPM, ACR, GRC. ACR's letter number such and such dated 26/2019. The position furnished by your letter under reference regarding the appointment of Sri L.C. Mojumdar, retired FA and CO as RIO in the major penalty DA and AR cases against Sri Ajay Kumar, and your request to allow to Sri Mojumdar to continue as RIO in the subject case was furnished to Executive Director Vigilance Engineering in the Railway Board. He is in fact and circumstances of the case has allowed Sri Mojumdar to continue as the RIO in the subject case. In this connection, the relevant extract of board vigilance noting are also enclosed.
You have allowed to continue.
And my lord, kind.
Allowed who was appointed engaged as inquiry officer before attaining the age of 70, but inquiry disciplinary proceedings is not concluded, then he will be allowed to conclude.
Yes.
Where is the rail board's power to engage?
Yes, yes.
After expiry of or after attaining the age of 70?
My lord, kindly consider the Railway Board Act, my lord.
To 235 as we have been shown.
That letter we have. 270.
Railway Board Act.
273.
Sir, where from you are producing documents?
My lord, I am producing the Act, my lord, Railway Board Act. That is only 2 sections, my lord. ওই এটা এআইআর ম্যানুয়াল থেকে জেরক্স করা Indian Railway Board Act 1905, my lord, the one short title, two investment of the railway board with the power under the Indian Railway Act, my lord, then my lord kindly come the three, my lord. Mode of significant communication from the railway board. Any notice, determination, direction, requisition, appointment, expression of opinion, approval or sanction to be given or signified on the part of the railway board for any of the purpose of or in relation to any powers or function with which it may be invested by notification under section 2 shall be sufficient by binding if in writing signed by the secretary to the railway board or by any other person authorized by the said railway board to act in its behalf in respect of the matters to which such authorization may relate, and the said railway board shall not in any case be bound in respect of any of the matters aforesaid unless some writing signed in the manner aforesaid. So, my lord, only the railway board has the power, my lord, for this relaxation. And my lord, kindly consider.
Where do you find that?
My lord, any notice, determination, direction, requisition, appointment, my lord, everything, expression of opinion, approval or sanction.
To be signed on behalf of the railway board by a particular person. Where is that document?
Yes, my lord, kindly consider that R.P. Joshi, Joint Director, Vigilance Stores, Railway Board. He was the board member, my lord.
Oh,
My lord, in railway board, 5 members are there. My lord, in respect of disciplinary thing, my lord,
Mr. Ghosh, we are not concerned with the constitution of railway board. Railway issued some letters.
Railway?
Issued some letters formulating some standard procedure to be followed in respect of disciplinary proceedings and other matters. So railway board is to reserve this power to modify the same.
Yes.
Unless this power is reserved, and if in respect of a particular disciplinary proceeding it is modified, then it would be an arbitrary exercise of power.
Yes, grateful, Your Honor. My lord, yes, kindly consider one thing.
You saw that railway, although issued some letter formulating standard procedure, but reserved the power to modify the same.
Yes, that is, my lord, that is the Railway Board Act. For this reason, my lord, my submission. And my lord,
considered it is in the
no, my lord, kindly consider that prior to if your lordship wants to pass any interim order or like that, my lord, in that case, my lord, kindly allow me to 5 minutes. My lord, because my lord, that is whether they have to, my lord, that substantiate that he was really prejudiced for that, but due to the age of 70 years. Kindly consider what the Supreme Court stated, my lord. Kindly consider that.
You are not explaining to us that where is that authority. My brother has
Sir, where
is the authority?
That authority under the Railway Board Act, my lord.
We are not satisfied with that. As such, we are passing an interim order.
My lord, kindly consider the judgment, my lord.
Judgment on what ground? That you have produced?
My lord, they have to, my lord, show, my lord, he was really prejudiced for that.
We will consider that.
Yes. My lord,
you bring on record.
My lord, I am only, my lord, submitting. My lord, my respectful submission that will consider by your lordship. That is my kindly consider that.
paragraph 33.
কিন্তু এটা ফাইনাল হিয়ারিং এর ব্যাপার না।
Proposition, my lord, they have to, my lord, they established that he was really prejudiced for failure of any procedural nature or anything like that.
Prejudice issue will come, can be alleged against a person.
My lord, kindly allow me to place, my lord, one paragraph only.
This is interim stage, Mr. Ghosh.
Yes.
So, my lord, kindly consider that the document
considered.
is there, and my lord, in the review also, in that they have also filed a review petition. And
Review is
both was
paraphrasing
considered.
the judgment. Tribunal has passed the order of rejection.
My lord, kindly, my lord, one paragraph, my lord, one paragraph.
Which paragraph?
Paragraph 33 of the judgment, my lord.
We will consider at the final stage.
My lord, kindly
change the
since
inquiry.
2021.
So you change the inquiry officer? Change it now today?
My lord, how
allow you
my lord,
to-
inquiry is completed.
Now why you are so wanting that inquiry officer should, your prejudice would not have been suffered if on the accepting this allegation you could have appointed a fresh inquiry officer. Finished.
My lord, inquiry since 2021 inquiry was completed. Since thereafter, my lord, he is enjoying the interim order, one after another pretext.
So is it his fault? His fault?
Yes, my
Tribunal
lord.
has granted the interim order.
No, my lord, that is the interim order was granted by the tribunal.
What
That is
order?
in the year of 20 since 20.
Sir, we are not in a quarreling mood. We have told you this is the ground. We do not prima facie find your explanation to be acceptable. We are staying that order. You come with your opposition. We will
And my lord, then in that case, my lord, kindly recorded that he was failed to produce, my lord, to establish the fact that he was really prejudiced due to the age of 70 years. Kindly record that fact. And my lord, the two judgment, my lord, one is 1996 3 SCC, and my lord, the another is, my lord, the 2012 11 SCC, my lord. My lord, in that case, my
Are you
lord,
holding the
and my
inquiry?
lord, one submission.
Are you holding the inquiry now?
Yes, my lord.
Are you holding the inquiry now?
Inquiry is completed.
Inquiry
Inquiry officer already submitted the report in the year of 2021. Thereafter, my lord, he was requested to submit his representation against the report of the inquiry officer. That was not done. Thereafter, my lord, they have filed the application before the tribunal. After rejection of the tribunal in 2026, again that opportunity was given. My lord, my humble and respectful submission is that, my lord, one submission another, that unless there is an order of punishment issued by the disciplinary authority, there are no cause of action, my lord. My lord, kindly consider that judgment of 2011 2012, my lord, 11 SCC, page 565, paragraph 10, my lord. Paragraph 10, 11 and 12.
You read the entire judgment now. We will
No,
listen
my
to
lord,
you.
I am paragraph 10. Please, my lord. Ordinarily, a writ application does not lies against the charge sheet or show cause notice for the reasons that it does not give rise to any cause of action. It does not amount to an adverse order which affects the right of any party unless the same has been issued by a person having no jurisdiction competency to do so. A writ lies when some right of a party is infringed. In fact, the charge sheet does not infringe the right of a party. It is only when a final order imposing the punishment or otherwise adversely affecting a party is passed, it may have a grievance and a cause of action.
Thus, a charge sheet or show cause notice is in disciplinary proceeding should not ordinarily be quashed by the court. So, my lord, kindly consider that it is only when a final order imposing the punishment or otherwise adversely affecting a party is passed, it may have a grievance and a cause of action. And my lord, in my case, in 2021, that the discipline inquiry officer submitted report, and my lord, the disciplinary authority requested him to made his representation. That was not done. Filed the, my lord, way before the tribunal, enjoining the interim order. After dismissal, again it was requested.
Yes.
So, my lord, kindly allow the railway to complete, my lord, the disciplinary proceedings.
Yes. Anything else, Mr. Ghosh?
And my lord, this judgment, my lord.
Which you
1996 3 SCC, my lord.
Mr. Sophie Judish.
3 SCC 364. Paragraph 33. And my lord, there is also
Thirty-three.
33.
32.
No, my lord. 33. My lord, we may summarize the principle emerging from the above discussion. These are by no means intended to be exhaustive and are the keeping in the view of context of the disciplinary inquiry and orders of punishment imposed by an employer upon the employee. 1. An order passed imposing a punishment on an employee consequent upon the disciplinary departmental inquiry in violation of the rules, regulations, statutory provision governing such inquiries should not be set aside automatically. The court or tribunal should inquire whether the provision violated of a substantive nature or whether it is a procedural in character. 2A, my lord, paragraph 33, my lord.
Yes.
Lordship got it, that paragraph?
Yes.
May I place, my lord, from the beginning, my lord? May I place?
No, you were placing clause 2.
Paragraph 33, my lord.
Yes, 33.
And my lord, 1.
In case you are in 3 now, in case of procedural provision.
Yes, my lord, I have not placed 2, my lord. 1, I have placed 1, my lord. A substantive provision has normally to be complied with us explained herein before, and the theory of substantial compliance or the test of prejudice would not be applicable in such a case. 3. In the case of violation of procedural provision, the position is this: procedural provision are generally meant for affording a reasonable and adequate opportunity to the delinquent officer employee. There are, generally speaking, concept in this
Sir, you need not read the entire judgment.
Yes,
you need not read the entire paragraph.
No, not entire paragraph. Mala, only one paragraph, 33.
33 is going to the principle which has been earmarked is in 1, 2, and 3. This is the principle earmarked.
Yes, my lord. Regarding the disciplinary proceeding.
Yes. Your contention is that there is no real prejudice. He participated in the inquiry.
Yes.
And your contention is that allow the inquiry to proceed, but no final order as regards that you consider.
And my lord, only, my lord, the final order is pending. My lord, that was not passed, my lord.
How final order will be pending? Inquiry report has to go to the disciplinary authority.
Yes, my lord, goes to
disciplinary authority has to issue a second show cause notice.
That was also done in the year of 2021.
Acha, 2021.
Yes.
Yes, when was the original application filed? Original application was filed in the year 2021 itself. An interim order was obtained.
Yes.
That continued for years.
Yes.
You did not take any steps for vacating that interim order. It has continued till the disposal of the judgment, the matter. Your order has been passed.
Order was original
Frequency
order.
26. So interim order continued till 5 years. You did nothing. Did you take any application for vacating?
My lord, one after another pretext, my lord, the matter was adjourned, my lord.
Yes. Do you have to say anything?
My lord.
You participate in the proceeding. Let it be completed. You come back to us. They will not pass the final order. We will decide the matter. Ashok.
Ask him to go to appeal.
Yes, my lord.
So the point raised by him would not be considered.
And my lord, provision of appeal is there, my lord.
Yes.
In the disciplinary appeal rules, there is a provision of appeal.
The present petition has been preferred.
Item number 10, my lord, I'm from the petitioner, my lord. The advocate on record, my lord, is suffering from fever, my lord. I'm praying for not this week, my lord.
Monthly list of August. Yes, next.
God bless you, lord.
My lord, I am appearing for the petitioner. I have served the copy. Is the affidavit of service.
ওটাই affidavit of service.
My lord.
Where is your affidavit of service?
Lord, I have served on 20th. Today is 22nd. Maybe there is some discrepancy in the
Next Thursday.
All
Yes.
deeply on.
No, not next Thursday. We are keeping it on 29th.
Wednesday, my
29th থেকে না? আজকে কত?
আজকে তো 22
31st এ রাখো, 31st July. Yes, next.
deeply applied. ये देखो दरकार नहीं.
Well, in this matter, Mr. Bari appears. Well, your lordship kindly grant 1 day adjournment, my lord. He prays only 1 day. Tomorrow, your lordship, or day after, subject.
Next week. Yes. Next 13.
But I appear for respondent number 11 in this matter.
The the complaint in the petition is the respondent number 12 being the promoter and 13, 14, the Thika tenant, obtaining a plan of 3 stories, constructed 6 stories building. That I am placing or I am drawing your lordship's kind attention to the answer given on the application under RTI Act by the corporation itself, page 23. And 21, 22 is my application.
Where private respondents have been served.
Yes, private respondent 12, 13 and 14, the office report is their door closed. It can be because of the fact, my lord, they are constructing in the, my lord, at that premises.
Show us your affidavit of service.
Door closed.
Actually, door closed, actually left without instruction.
Oh, actually, left. One is left without instruction.
Find out the pages where is your service. Yes, what is your case, show us?
Yes, Lordship, kindly come to page 23. Before that, I should show the questionnaires. What was the information sought for? Kindly come to page 21. That is my application under RTI Act. First question: what is the date of sanction plan regarding the above mentioned premises in questions? Number second, for how many floors the sanction plan is been issued? Now, Lordship, kindly come to next page 23. Next to next. That is the answer of 1, 2. In reply to the queries number 1 and 2, the premises in sanction for 3-story residential building on 29/10/2024. I annexed the photographs on page 24, and this is my specific allegation that they have already constructed 6-story building. 0.5 paragraph one, they have also 6 stories.
So where is your question that how many stories?
Page 21.
No,
That's one second question.
Sanction for how many floors the sanction plan is issued?
No, that is not the
3-story
question, but they have given the answer 3 stories.
3-story.
3 stories.
Now you're saying there has been 6 stories.
This is the feed case for 401A and 400 subsection 8, subject to lawsuit and correction.
Who are you?
They are sitting tight over the matter. I am a public spirited person, my lord.
Public spirit occasioned only in the year.
Lordship, I am coming on that, but at least I could, if I can bring to your lordship's judicial notice, there is flagrant violation.
Yes, what do you say?
I'm only sorry, Babil, that this is the gentleman like but some other also person, they move around the city and they always go for one of the another to purchase the another's property. Before my learner while taking that information whether the construction or the unauthorized or
Now,
not
what
that.
is your instruction?
Mine said that already before he moves to the court, before he takes that information, I had already taken steps. It is in process.
What steps you have taken?
Where stop work notice and demolition the proceeding.
Under which protection?
After giving hearing to the parties, this is the report has come. Only I could not because he says the 3-story might be my client mistake or he has mistake. He says the 4-story over that ballot possibly 2 floors have been erected. But so far as the 4 or 3, that I will ascertain whether sanction up to 3-story or 4-story. But over that ballot, another construction structure is there.
Picture shows Mr. Ghosh 6-story.
The 6-story, I say the construction is there up to that. But sanction part 3 or 4, that is ballot.
This is found RCC 4-story. It has been constructed. These are 3-story. Already initiated a 400 proceeding.
My lord, 400 under subsection 1 or subsection 8 first.
1.
I am pressing, my learned friend submitted that they are very agile. Before my filing my petition, they have taken steps.
No, we will dispose it of asking them to decide that proceeding.
Kindly bear me. Kindly bear me. I will show the continuous action of the corporation authorities in indulging these sort of illegal activities for the reason known to them. Lordship, kindly allow me to place Rule 35 of building rules. It is their statutory obligation to inspect. But before I lodge the complaint or I made the request, I don't know what is the date of initiation of
They
that.
have inspected.
Lordship, kindly come.
Go through these and
Yes,
then
Lordship, after that,
affidavit of services.
Regarding notice under section 401 was given on 20th December 2025.
I will exhibit to your lordship that itself is aggravation.
And you filed this petition in July 2026.
July 2026. But my representation also kindly come to June.
Your representation is June 2026.
I don't know where.
Before taking any steps by you, the corporation has already issued a notice under section 400.
First hearing had already taken place.
And even for 400, they are initiating proceeding under 400.
400 subsection 8 is attracted. I am exhibiting here and now to your lordship.
You participated.
Also.
You participated in the hearing, Mr. Babu.
Then they should stop everything. Nobody should allow to take position.
Therefore.
Further, divorces case has been improved after making inspection under the direction of the specialist building.
What do you want, Mr. Babu?
You want for an immediate demolition under a different provision.
Let
You
him
want
say that now, Mr.
This is what.
Hey, let him say that.
No, I will pay up to the last extent. Your lordship will give me only 10%. That I know. If I am not entitled, I cannot get the last extent. What initiation they have started, taken, at what time, why it has not been sent to the appropriate authority, it is to be dealt with. I will draw your lordship. I will not just most humbly pray with your lordship an opportunity to deal with this. If this matter after any day, and in the meantime, let them not to allow to give possession of any part of that building. I have completed fire.
People are residing there. People are residing in that.
He is complaining, my lord. The complaint also say, I have not taken any action. Inaction has been complained of. If he says, my lord,
that is the illegalities. I am pointing out before your lordship. That is the illegalities that indulges these sort of.
How many cases he has filed before this court on
allegations? Kindly allow me to place Rule 35 of building groups.
No, may be permitted, my lord, in respect of respondent number 11, my lord, I could not find any prayer or any averment against us. My lord, may my name be expunged, that is first. And secondly, my
They
lord,
have chosen you. What is your problem?
To stop the electric supply, electricity though.
and in respect of the premises, my lord, my instruction is we have not given any connection, my lord.
So,
You have not given.
After the completion certificate is obtained, my lord, there is a scope, my lord, the correction, other civic benefits that cannot come up.
This report that somebody is in position is further collusive action.
What does he want?
Absolutely collusive action. Why is that? They have already taken steps.
Regarding the connection, what we have
If
taken,
he
that is,
wants,
we have not received.
he can my lord, approach. He can approach the Board of Special Officer building to my lord, make his because he is the complainant. He will let him go there.
Let him
go there because he is the complainant to go there support his contention.
How he will be appearing?
I cannot, but he is vociferous before this court that when the proceeding has already been initiated.
You appear to be more vociferous, Mr.
Veracity of your illegality.
Only thing, well,
Mr. Devarman, we will ask the corporation to complete this proceeding within a stipulated time. And if you allege the point of Rule 35 and everything when the final order is passed, let it be disposed of. We will record the submission.
My client who is represented. And
you have no right to participate.
You have no
there,
right
Mr.
to participate in the hearing.
400 proceeding. What?
Any third party, whether any third party has a right to participate in the proceeding, the violator and the department have to complain.
Will you give a hearing to him?
Will you give a hearing? Just as he has said.
I cannot give it because when I have
going by the party, but
I under the law, my lord, person responsible is to be heard.
Person responsible. No, he is the.
He's not the person. He's the complainant because he's not the person. He may initiate the proceeding.
Okay.
But only thing, no new connection application has come forth. I was wrong in
We will record that.
And there is no allegation, nothing against me. Let my name be.
There are allegations.
The present petition has been prepared in form of In accordance with law, dispose of in accordance with law.
No, respondent.
Oh, private respondent here.
In that place, well, a person responsible will be better. But I don't know, my lord, whether the private.
We have seen one side of it is yes, illegality is being done. But you will be surprised to note we have seen many petitions. The next door neighbor. 10 years he doesn't say anything.
This is the well such as this law. This is a common wrong.
We are not on that. You have not heard us. What we are saying is this public by virtue of guise of public interest litigation. These advantages which are sometimes taken, we always prima facie believe you. We prima facie believe the council.
And I am also not in position to ascertain everything of my client.
Exactly.
Like I do
This is a social problem. This is happening.
This is also a social problem.
No, we have entertained.
Next,
it will be able to come again if the proceedings is not properly conducted. You will come again. Your first bill has been entertained. So,
yes, next.
49 appear for the state respondent, Lordship.
State, yes.
Respondent number 3, Najia Ilahi Khan, my lord, used certain abusive words and derogatory words against the Prophet Muhammad, who is respectable by the Muslim community. And the word used, my lord, by the speech, paragraph 4, kindly see, paragraph 4.
You have completed service upon respondent number 3.
3, door locked.
Where is your evidence?
Yes, I will give him that.
Lordship, this is essentially, may I submit, Lordship, this is essentially.
Wait, we will hear you. Yeah. You should mark the page where it is. We are not here to.
Last page. Finally, the remark, door locked. Now, kindly see, my lord, paragraph 4 of my petition. The Najia Ilahi Khan used abusive, false, and hurtful words.
But this title does not tally with the cause title. In cause title, you have given Nazia Ilahi Khan. Oh, these two parts.
Nazia Ilahi Khan.
Yes, what you are showing and
used abusive, false, and hurtful words against the Prophet and religious of Islam and hurt the feelings of the Muslim by derisively insulting the religious belief mentioned
all right,
in the
let us go through it. Now, what happened? Why you have come up here?
Because, my lord, he is residing in Calcutta and 2 FIR was lost against her in Bombay. Now, my lord, we also, I am praying, my lord, let the FIR be lost against her in Calcutta.
Where is your complaint?
So, kindly see the Supreme Court judgment. Kindly see the Supreme Court judgment on the same issue. Even on kindly hear me too.
Have you made a complaint?
No, I did not make any complaint. But even the Supreme Court has observed, even without having complaint, If that issue is raised,
this is not a case where there is no complaint. Other states there is a complaint.
well,
What is your
Lordship, my submission will be this is essentially a prayer for inaction of the police. Now, this is a judgment of our honorable court where a PIL has been held to be non-maintainable against a non-registration of an FIR.
Have you taken any steps?
Lordship, there is no complaint. Only the Directors General's office has been made a party, directly has filed the writ petition. There is no complaint before your Lordship. What my learned senior friend is wanting to rely on is Lordship, that there is already cognizance has been taken of this issues in several states. He has enclosed that it is with his petition. There is nothing brought before any jurisdictional police station.
Supreme Court judgment, page 33, relevant page 34, last paragraph. I am reading that judgment, is very important. The same issue was cropped up before the Honorable Supreme Court.
And
page 34, last paragraph, I am reading that the respondent number 2, Commissioner of Police, New Delhi, respondent number 3, Director General of Police, Uttarakhand.
What are you reading?
Page 34 of the Supreme Court judgment.
Here, Lordship,
On
cognizance has
last
been
paragraph, can you
taken
see?
by other states.
The last part, one paragraph. Respondent number 2, I also got it, my lord.
Yes.
2, Commissioner of Police, New Delhi, respondent number 3, Director General of Police, Uttarakhand, and respondent number 4, Director General of
Why
Police.
will you not file a complaint? We don't understand. What prevents you from filing a complaint?
Since Supreme
You're
Court
showing Supreme Court order.
now without
that
complaint,
any person will come and say, I will not lodge complaint. Supreme Court has said so. Is this the process? You have a complaint, you're coming to High Court.
without complaint.
Sir, what is your problem to lodge a complaint? That this is my problem. I cannot lodge this complaint. Mr. Dotto, what is this? Lodge a complaint, we can direct them to investigate and finish it up. Withdraw it, file with a better particulars. Lodge a complaint in the company. We are recording that, Mr. Dotto, on the prayer of Mr. Dotto. Next.
Your Lordship, I am for the petitioner. My senior is appearing virtually, my lord. Is appearing virtually.
My lord, I am appearing on behalf of the petitioner, my lord. This is with regard to, my lord, running of an unauthorized khatal in Howrah. Corporation in February 2026 had even cancelled the certificate of
service is complete.
Yes,
regularities
here is my service.
that has to be followed.
You served
Yes, ma'am. By the respondent.
Yes, my lord, I have served.
Yes, ma'am. Now, my lord, Howrah Municipal Corporation on 17th of February, my lord, had cancelled the certificate of enlistment. And even, my lord, for running
My lord, page number
My lord.
24.
page 24, my lord.
Page 24.
And 25, my lord.
My lord, this is the order of cancellation of enlistment of the private respondent. My lord, kindly comes to the page number 25, the penultimate paragraph after paragraph number 4, my lord.
This is
In reference of
somebody else. Yes, what in reference to certificate of enlistment is finally. There are pending writ petitions.
There are, Your Lordship.
You are for the private respondent.
I am for the Howrah Municipal Corporation. Kindly seize the affidavit portion. Where is her residence and what place she is complaining of? Kindly seize the affidavit portion. Who has affirmed the affidavit? Lordship, I, Kia Patra, it is at page 19, wife of so and so, aged about so and so, residing at 16 2x2 Haldarpada Lane, Howrah Corporation, Post Office Satragachi, PIN is 711104. And the disputed property is 34 Dharmatala Lane, Howrah 711102.
Tell us what you have done after this, page 25.
Your Lordship, this
No, my lord, my lord,
after this,
on
Your
one,
Lordship,
one,
the writ petition is pending. Possibly it is listed next week. The records of the corporation is required to be seen by the learned single judge who is in session of the matter.
That those two writ petitions.
Your Lordship, two writ petitions, the numbers are 8482 of 2026 and 9024 of 2026.
Very good. When it is fixed?
Next week, 27th of July, next week.
27th July. Then we take it up thereafter. What is your action in that?
yes, well,
It's private
my lord,
We have
responsibility.
already taken our actions.
only,
They have challenged the persons whose license have been cancelled, have preferred, have challenged,
no,
assailed this
no.
order, and that is pending, Your Lordship. This is
No, my lord, no, my lord. My learned friend has a mistaken of fact. What we say, my lord, to run a khatal, certain permissions has to
Sir,
be
you
taken from the
you have
pollution
not
control.
heard what we have said. This is the
No,
problem
my
in
lord.
online transmission. We see from page 25 reference to two writ petitions.
Yes, my lord.
We asked him that what is this status of those. He says that it is fixed on 27.
My lord.
You come with what is the order passed on that day. You come to us. Now,
No,
why
my lord.
public interest litigation again?
Yes, my lord. That is what I was explaining, my lord. My lord, for running a khatal, my lord, there are few, my lord, regularities which has to be complied with. My lord, one is
Very
to
good. Then
consent
you
to.
get yourself implemented in that writ petition and
My lord,
ventilate your grievance.
Pollution Control Board has to file a report with regard to the same.
Which one?
Howrah Municipal, my lord, in that aspect, through Rana Khatal, my lord, consent to establish, consent to operate, my lord, anybody husbandry certificate, FSSAI license to run a milk farm, that has to be given by the Pollution Control Board. We require a report from the Pollution Control Board, my lord. We have made them a parties, we have even served them. Make already calls for a
Howrah
report from them.
Municipal Corporation, Lanet at the Council, Howrah Municipal Corporation already taken steps and issued a notice to Bodhi Narayan Jadhav. Now you
Yes, my
making
lord.
his son Vicky Jadhav as a private respondent here, you are seeking further
Yes,
action.
my lord, kindly looks to page
The
24. Yes,
corporation
why
has already taken steps against. Already taken
But
steps.
yes, my lord, but for that,
License is blocked at present.
yes, my lord.
And all findings will be submitted against such and such. This is to inform you, license department will lock all these three holdings in license software from generating a real-time certificate. This letter was issued Bodhi Narayan Jadhav, and you made Vicky Jadhav son of Bodhi Narayan Jadhav. Now
Why I say why
making
do I
making
why
private
do I make my
respondent of the
Where is that? You want no consent? Pollution Control Board is required to do it. Where is your representation to Pollution Control Board?
page number 20.
We take it up on that date. 27th
My
is
lord, my lord.
27th is the
come on 1st August.
My lord, 1st August is a Saturday, made on 5th August, my lord. 5th August.
Appearing for the petitioner, affidavit of service, as file be kept on record. Mr. such as the learned advocate appearing for the municipality. Is list this matter for further consideration on 10th August.
Yes, my lord.
Appearing for the municipality is directed to avail necessary instruction in the meantime. Come and tell us on
Grateful.
Grateful to you.
Grateful, my lord. Grateful, my lord.
বলছি
PM fixed matter 24 to 26 for order.
My lord, in this matters, your lordship, I am appearing on behalf of the petitioner, your lordship. I am being led by Mr. Kollol Basu. My lord, he is out of station. That's why I am only praying for an accommodation, your lordship.
It
Any
has
day
almost
convenient.
been hard.
Yes, your lordship. We have almost.
Would have mentioned before us tomorrow, he wouldn't have come then.
My lord, yes. We have already intimated them.
Naturally, because this is a part heard, you are not allowing us to
Yes, your
release the
lordship.
matter.
My lord,
At
I
the same
apologize
time,
for
you are
that.
insisting for early hearing. We made out time and fixed it. When we will again sit and take up the matter, we don't know.
My lord, I apologize for that.
Lord, next week, this day, this time, subject to my lord's pleasure.
There has to be some. You could have told us 2 days ago that this is the problem. We wouldn't have kept the matter. দেবে কোন দিন আছে দিয়ে দাও। অন্যদিন অর্ডার নিতে হবে ওইখানে ফাইল দাও
Item number 16.
My lord, I am for the petitioner, my lord. This matter, my lord, Jayanagar Mujidpur municipality is the answering respondent, my lord. But from the track record, it is not clear that they have received or not. Municipality? No, my lord, I am appearing for the state. But from the track record, it is not clear that they have received or not, my lord.
Yes, service.
The learned advocate appearing for
At 17 late, I'm led by Mr. Bhattacharjee. He is arguing on a matter for another court that can be taken up on Monday. Possibly they are also
Monday. We have many matters fixed.
in the meantime, let prayer D is let innocuous prayer. If they provide this notification, prayer D is not available in the website, then we can file a supplementary affidavit also in the meantime.
Mr. Shami Ahmed, learned advocate appearing for the petitioner.
But I appear for the respondent 11 and 12. Pollution control, your lordship. On last occasion, your lordship was please, but appear for the private respondent, 11 and 12, my lord.
And I'm appearing on behalf of the State Pollution Control Board.
But on the last occasion, my lord, my learned friend has handed over a notice, my lord, indicating that Pollution Control Board, my lord, has issued a notice.
Hearing notice.
Hearing notice, my lord. That notice was never communicated to the petitioner, my lord.
But
And the address which has been mentioned, my lord, it is.
stay.
Was handed over by the learned advocate of the petition on the last occasion, hearing notice that the Pollution Control Board has called a hearing on, my lord, the 8 July 2026 on the date of hearing itself, my lord. That notice was never, my lord, the communicated to the private respondents, my lord. And the address which is mentioned in the notice also is incorrect, my lord. It is not my address, my lord. That's why, my lord, I could not. I am for the private respondent, my lord. We could not participate in the hearing, my lord.
Last occasion, my lord, was
And my lord, we have
file a report.
and
By
we have
state pollution.
and my lord, we have sought to, my lord, communicate the Pollution Control Board to, my lord, fix another date, my lord, since, my lord, on 8 July the date was fixed for hearing.
For the pollution, so any.
I have submitted a record of proceedings before your lordships.
Oh, they have passed an
Yes,
order.
we have passed an order.
This order is appealable.
Yes.
You prefer appeal?
But no hearing behind my back, my lord, that this order has been.
Take that point.
Take this point before the appellate forum.
Immediately to restore. This is not your writ petition.
No, my-
We did not pass any order also. We said we were informed 8th is the hearing because we did not pass any order against you.
No, my lord, kindly appreciate that our predicaments, my lord, no notice was communicated.
So we will record that.
And behind our back, my lord,
we will dispose of the petition. We will record that, and you would be
But
at
the-
liberty to take
and
appropriate.
Pollution Control Board had granted license in my favor. Now, my lord, the impugned order has been passed, my lord, as it appears, my lord. No, that also, my till that my has not been communicated to me, my lord.
Which interim order?
That impugned order, my lord, perhaps, my lord,
She will be giving you a copy here and now. What is the problem? Yes, Mr. Rao.
My lord, what has happened, my lord? Yesterday, my lord, hearing before this learned court below, my lord. Civil court, my lord, has no jurisdiction. My lord. At the time of hearing, my lord, private respondent, my lord, my lord, my learned friend clients, my lord. So this is the pending before this honorable high court. That's why, my lord, make it.
Civil suit filed by whom?
Civil, my lord, civil suit filed by this, my lord, challenging this SDO order, subdivisional control, subdivisional district officer order, challenging by this, my lord, respondent.
that was.
Your grievance is you are a public spirited person. They are running this without any appropriate permission from authorities. We will record an order. We will record that it has dismissed his license has been cancelled. We'll put that on record and we'll dispose of the petition.
And my lord, kindly, my lord, direction, my lord, implementation of this, my lord,
Lord,
order passed by this Pollution Control Board.
Statutory time is provided. If not
Officer in charge requested.
And my lord, central
officer in charge has already been requested to carry out.
Oversee the compliance of this order.
Ensure that the order he does not carry out any poultry farming activity
at the present location.
But the rights have been affected, my lord. But without giving opportunity of hearing, my lord. But we are running the poultry farm, my lord, pursuant to the license granted by the PCB.
In course of hearing.
But the civil court has granted.
government land and over the Noinjoli. For which my drainage system has been blocked. My petitioner made a representation.
Before whom?
I'm the local inhabitant, madam.
Before whom you made it?
Before the various authorities, including the DM. Page 15.
DM.
Kindly see the before
DM
that
will consider.
records. Records shows page 13.
This
This is Paka Rasta. Next page is Noinjuli.
Yes.
You are for whom?
I'm for the private sector.
Any proceeding initiated against you?
No, till now, my first contention is this, my lord. I am the owner of the priority plot number 40407. But here the instant petition, my lord.
Controlled by the national highway, state highway, controlled by the national highway. It's come under
This is a highway.
No.
Oh, public works.
record shows. Record shows. Page 13.
National highway.
National highway. And
my space
page 14 is the
You
Noinjuli.
are sending it to him. You both of you will be hard.
My lord, your lordship may be. My lord, before that, my lord, kindly give me a minute, my lord. My lord, this petition was prepared by the petitioner hearing, treating the said land as a state highway land. Number one, in a very casual manner, without implementing the National Highway Authority as a party respondent in this petition. Just
DM is the appropriate authority.
just make a joke, my lord, before this honorable court to treated this honorable court as a letterbox, my lord.
No, DM has been.
If Highway Act is applicable here, then respondent number 4 shall consider.
DM is the appropriate authority. National highway.
Respondent number 4 is the appropriate authority.
I am not in that.
Okay, you raise all these points before the respondent number 2.
Government in the entire petition, just if made a representation before the authority concerned on 1st June, my lord. It came before this honorable court on 17th June.
Respondent number 2 is the appropriate authority.
Highway.
Kindly see the record.
Record whatever. What is your averment in the writ petition? So see the record. See the why you have not discussed that.
Government land. Government land. I have said government land.
So government land, whether it is highway land or under PWD, you have to make a specific stand, na?
That is.
You cannot go on beating your drums in every office.
Government
Make up your mind.
Government by the 62 Act.
Public works department.
No, 62. That is a
If it is a government land, then it is by the 1962 Act.
District magistrate.
Why?
Kindly see the notification.
What notification?
The power has been delegated to the district magistrate.
Show us.
If the land is the national highway.
National highway.
The land is national highway. My contention is this land is the national highway. But in the entire averment, entire repetition, there is no whisper. Just in a very casual manner, made an application and just filing the set.
Second page.
Come before this honorable court. It is true. National Highway Authority, DM is the appropriate authority.
Section 26.
Yours is which section?
My lords,
illegal construction, then section 26 is the.
Power has been delegated to whom? Under which section?
Section 21 says power has been delegated to.
Where is your book?
The notification says.
Notification says section 21.
Thereafter, my lord, can you see the box column? District magistrate.
Executive engineer.
No.
Notification dated 29th October 2025. 21 in exercise control of petrol.
What are these 26? Have you brought the Highways Act book? इनको क्यों मामला करे?
My lord, on section 26, my power has been delegated.
Is it not your duty to go through this provision before filing the writ petition? Is it not your duty? What sort of petitions are you filing?
My lord's report. We have a report from the state.
Show us what
Yes, my lords.
দুপাতা লিখে দিলাম
My lord, this does not fall under a jurisdiction because the land is owned by the PWD Union of India. So
PWD
Union of India. My lord, if I may, if the petitioner's own petition, my lord, if I may assist my lord to page number 13, my lord, of the petition that has been filed. My lord, if we see this, the Poshchimbongo Sarkar Samoshti Bhumi or Bhumi Sanskar Odhikaroner Koron, my lord,
page
13, my lord.
13.
13.
Yes.
My lord, Rayote.
This belongs to PWD.
National Highway belongs to central government.
Union of
Yes,
India.
Union of India.
Yes.
National Highway bole.
It is National Highway.
No, PWD Union of India.
As a PWD Union.
Union of
So who is the authority to take steps to evict the unauthorized occupant?
National Highway.
Well, my lord, the National Highway authorities will take the steps.
Through whom? Through DM?
No, my lord. But there was
another writ petition. Attendance. So you conducted an inquiry
The National Highway Authority has
on the basis of an order passed by High Court.
That was not.
Why are you occupying the land?
I am not occupying. I am occupying 407. That is my right to plot of land. If any encroachment is there on my part, then must be.
They have already found encroachment on your part. This is the report. This is the report.
That report was that.
Must have. It was done in your presence.
My lord, I have no objection about
So
that.
if you
I have no objection about that.
What is your name?
My name is my lord. I'm 6 to 10, my lord. I respond and Swapan Panda, Shakti Prasad Singh, Shamoli Yadav.
Okay.
Papers which you have handed up.
Yes, sir.
Come to the 5th page, attendance sheet. What is the name of the petitioner?
Prabhati Samanto.
Prabhati Samant. Yes, she was there. You were there. No, only instruction niye aso. You have made no difference about this writ petition number in your petition. That means you do not know Now, ultimately, what has happened thereafter? After BLRO forwarded this, yes, sir, to the assistant engineer PWD.
Yes, my lord.
What had been steps taken thereafter?
My lord, no steps have been as such taken because the BLRO was of the opinion that this land belongs to the PW Union of India, so the steps need to be initiated by their on their side, my lords, and they have not been implemented as a party in this petition, my lord. So if
No, what is this writ petition about? 318 of 2026?
Probati Savanti.
318
Same, this is same petition, my lord.
The public interest litigation that I marked the
Yes.
P within bracket P, that was not there.
318 or 20.
318 this is
Oh, this is
The same, my lord.
petition. This is the same. This is the same, my lord.
So, what is your name, private respondent?
Six to all the private respondents. All the private respondents, all are present at the time of field inquiry.
Petition.
That is true, my lord. But the said inquiry was conducted by the concerned BLNLRO at the instance of the executive engineer PWD. That is as per the West Bengal Highways Act. That is the as stated as a West Bengal Highways land. But fact remains quite different. Properties belong to the National Highway. Nobody of the National Highway Authority was made party.
In that case, control of national highway, land and traffic act 2002 will come. And most probably, have you brought that act?
No, I have not.
You have also
Section-
not brought
Section
that.
26 provides for removal.
The 26, whether the power to evict the unauthorized
Yes,
occupant.
yes.
This power has been vested to DM.
DM. I have given the notification.
Yeah, have you will not
No, he will not bring the act.
bring the act.
He will not bring the act.
Here, certain power has been given. Power under section 27, 26, 36, and 43 has been delegated to district magistrate. The what 26 says, court will not see. He will not bring the book.
To my personal defect, I have to.
After filing of the petition. Would be the competent authority to decide this issue.
My lord, can the Union of India be implemented in this?
We will implement.
Yes, my lord.
First, you let us know
Fine.
and let him come with the act.
Fair enough.
You also take instruction and come.
My lord.
Let him satisfy us also.
Absolutely, my lord.
Then, if the National Highway Authority is required, we will implement them.
Definitely, my lord. Definitely.
Hardly learned advocate appearing. এই অনলাইনে online we will not use. Somebody appearing online when he is coming.
20, my lord, I am being led by Mr. Bhattacharya, but Mr. Bhattacharya is,
So what is the come? It is difficult to hear online.
my lord, 21 probably, my lord, Mr. Bandyopadhyay is appearing virtually.
He has difficulty, my lord, till August.
Till August.
Till August.
But since Lord,
Then how can we?
21 is a separate application. My lord, 20 is our application.
20 is your.
But my lord, he was online আছে
20 is with 21.
Yes.
Lord, he has instructed me that he'll appear online for 20.
But only one thing, my lord.
Ask Mr. Bhattacharya to appear tomorrow. Yes, not today. Next.
Tomorrow. So tomorrow, my lord, may be kept next week, my lord.
Let it be there tomorrow. Let us see. Yes.
But the assurance pertaining to Vidyapati Setu that continues. But
Tomorrow
my lord,
we are taking Mr. Bhattacharya.
No, my lord,
Tomorrow, if you have any further instruction, come and
yes, I have the instructions. We need to proceed, my lord, with this, my lord, the operation, my lord. It's not continuing pursuant to the assurance given, my lord. But
right, we take it up tomorrow. Ask Mr. Bhattacharya to come.
My lord, I will, my lord, till that time, my lord, no eviction should take place, my lord,
that's
till the
what I'm
next
saying.
day.
That is what I'm submitting. You have a problem, sir, in whatever I submit. With
I have a,
Yes,
my lord, I have a problem with eviction, nothing.
Matter is in the list. Mr. Bhattacharya has assured.
Mr. Bikash Ranjan Bhattacharya never does this. Unfortunately, this is done by his junior every time.
But he is under anxiety.
July, there was direction upon the state and private respondent to furnish certain records.
So we choke.
Choke.
You are for whom, Mr. Bhattacharya?
My lord, I am for the state respondents, my lord. No, my lord, pursuant to my lord's last order, dated 8th of July, my lords were my lord, pleased to direct us, my lord, to place on record the final decision, if any, taken by the medical board. This pertains to, my lord, the quacks practicing as ophthalmologists, my lord, whereby, my lord, one person, the person who is the gentleman who has filed this public interest litigation, he said that he has incurred some, my lord, for this treatment, some disability pertaining to his eye. Now, my lord, there were two medical boards constituted, my lord. One pursuant to, my lord, the FIR which was registered, and the other pursuant to, my lord, the directives of the medical council, my lord. Now, my lord, the first medical board says that as regards the treatment was conventional treatment. So the treatment was in terms of, my lord, whatever medicine was to be applied for the difficulty the gentleman was suffering from. But insofar as, my lord, the report of the second medical board is concerned, my lord, it says that the person who prescribed these medicines, he was an optometrist. An optometrist is only qualified to recommend power of the two eyes. Retinal infraction, nothing beyond that. But this man, this gentleman, he went on to act as an ophthalmologist. So this is again, my lord, something dehodes the powers that he has, or the limited, my lord, responsibilities that he has. But and insofar as the criminal case is concerned, investigation is ongoing. But he approached, the private respondent approached, my lord, the Honorable High Court, and, my lord, he has been, my lord, enlarged on anticipatory bail.
Mr. Bhattacharya, why you are not stopping the clinic?
Clinic has been stopped.
Clinic is still running.
My lord, directs me, my lord, I'll immediately stop it, my lord.
Medical council has given any direction to that?
No, it has been submitted. The report of the
Medical board has
board
submitted
been
report
submitted.
before the medical
It
council.
has been, what I have, my lord, is, my lord, it has been submitted to the CMOH. I'm sure for onward transmission, my lord, to the authorities which directed, my lord, this particular board to be constituted or inquiry to be made.
Investigation of prayer was made by the council or registration by the board constituted.
Okay.
Registration দরকার
রিপোর্ট গুলো কোথায় আছে?
16A
those reports with your party.
Lordship,
I
I
will
shall
do.
come back with exception if required, Lordship.
Can I copy the order? I am not supplying any report to the accused. It has, my lord,
He will xerox it.
the investigation is underway. The FIR.
Oh,
Court's report, my
no,
lord.
no, the medical.
Court's report I will submit in supply independently to him. ওনাকে দিয়ে দিও ওনার নাম্বারটা নিয়ে সর্বর বাবু আছে হ্যাঁ ওনাকে দিয়ে দিও রিপোর্ট দুটো রিপোর্টই দিয়ে
Now,
দিও
Mr. Bhattacharya, we find an inquiry report addressed to the chief.
Yes, CMOH, my lord. There are two.
This inquiry report is of the.
Yes, my lord will find.
By deputy CMOH, ACOMH, and MT.
Yes, one at page 7. That is one inquiry report. And the other one, my lord, will find at page.
The page 7 is the same as page 20.
No, page 20 is, my lord, the different one. The other one where
30th July. Page 20. Oh, this is 4th August.
Yes, this is up. This states about the competence of the person. Page 7 states about the treatment which was given to the petitioner.
So, Mr. Bhattacharya, why don't you file a report? We asked you to come a. No. Final decision. The medical board which we were told was consisting of the CMOH and another 2 persons.
But here
Now,
also,
you are saying that there was a medical board on the dictate of the medical council.
Well, it seems
Where
so,
is
my lord.
that?
Highly text page 21. In reference.
21 is the same as the. Come to page. This inquiry report, that is page 7.
No, page 7 is, my lord, by the.
Signatories. Kindly see the signatories.
Yes, it is by the CMOH 3. Chairmanship of the CMOH 3.
And
whereas
this
this
is
one is
but
CMOH 2, 21.
Lordship, this is not the medical council authority.
So this, but the second report, my lord, the one at 21, my lord, it transpires, my lord, that it was, my lord, letter received from ADHS NPCB VI, my lord. So it was from
Where is that letter? 4th of September.
But that I need to come back with, my lord. But these are the 2 reports, my lord, which are there.
And formation of medical board is that page, your Lordship will find that page 31 of my writ petition.
Mr. Bhattacharya, pertaining to the issues asked.
Prayer. Since I have served copy upon the principal secretary, so let there be a report from the principal secretary.
Come that day.
May also restrain in the meantime from the private respondent
Lordship
from performing as an ophthalmologist.
Performing as
He's an He's an optometrist. He cannot perform.
That is to be determined.
No, what is that is what is transpired also, my lord. He also never claimed that he is an ophthalmologist.
Are you running the clinic?
I am running the clinic
Lordship,
as an
Lordship.
optometrist in terms of 2025 syllabus. Or I am 2025 permits me to practice.
On that date state, I have the authority to act as an ophthalmologist.
No, optometrist.
Today you are
optometrist. That's right.
Lordship, kindly direct pass an order for closing down that clinic.
Permits me to practice.
Otherwise,
Come on
public
the
health.
returnable date.
Said I have
Answer.
physical practice.
Oh, come on that day.
I'm good.
So the IPF, my lord, the petitioners. Well, this is, my lord, public interest litigation. My lord, it's a continuation of, my lord, the two previous rounds, my lord, in which, my lord, this honorable bench, my lord, was pleased to consider the
What is
matter.
opposing you, Mr. Dotto?
But I think on the last occasion,
Somebody appeared, no?
Yes, yes, yes. I think Mr. Mishra had appeared.
Advocate General AG would appear. Mishro.
Yes, I think, my lord, subject to correction, সেদিনই তো ডেটটা ফিক্স হয়েছিল, হ্যাঁ।
AG would appear. Have you given a notice to the Advocate General?
No, I think, my lord, again, subject to correction, recollection, he
Mishro appeared.
informed the court that the learned AG would be appearing.
Yes. Mr. Why don't you see if Mr. Mishro is there or not? Yes, Mr. Dotto.
Yes, ma'am. But only to, my lord, for your lordship's recollection only. But initially, my lord, the first writ petition, my lord, or the first batch of writ petitions, was, my lord, the challenging, my lord, the declaration of the OBC post 2009. Previous to 2009 or up to 2009, my lord, there were 66 classes which were declared. Now, my lord, post 2010, my lord, the declarations and, my lord, percentage of reservation for the OBCs and classification of OBC into A and B, my lord, fell for consideration before this honorable court. But your lordships were pleased to, my lord, retain the 66 which were declared prior to 2010, and, my lord, were pleased to set aside the declaration post 2010. Your lordships were also pleased to, my lord, declare some of the provisions of, my lord, the 2012 Act as ultra vires. Your lordship was pleased to interpret one of the provisions by saying where it is said the state government, it is not the state government in its executive capacity, it is the state government in the legislative field. And, my lord, your lordship was further, my lords were, my lord, further pleased to reserve the rights of the people who had got the benefit under the 2010 notification. These were, my lord, primarily, my lord, the findings of this honorable court. Then, my lord, it went up for challenge before the honorable Supreme Court. But the Supreme Court was pleased not to stay your lordship's orders. And at the same time, the state informed the Supreme Court that in terms of your lordship's order, my lord, a fresh exercise is being undertaken. That was noted by the Honorable Supreme Court. Then, my lord, the fresh exercise was undertaken. Again, my lord, there were certain declarations. Again, my lord, there were classification into A and B. And, my lord, as per your lordship's previous direction, my lord, before the second declaration, my lord, the matter was placed before the Legislative Assembly. And then, my lord, it was declared. This declaration, post the 2024 judgment of your lordships, again fell for consideration before this bench. Then, my lord, your lordships were pleased to stay the operation of whatever was done after your lordship's order. So that order, my lord, went up for again, my lord, before the Supreme Court. Your lordships of the Supreme Court was pleased to stay this order, the second interim order of your lordships. Then, my lord, the Supreme Court was insisting over two matters where there was a contempt proceeding. Certain orders were passed. The Honorable Supreme Court again was pleased to stay the contempt proceeding. These are possibly not be of much importance today. Then, my lord, there is a change in the ruling dispensation in the state. But after the change of ruling dispensation, again, my lord, certain notifications have been issued, my lord, on 18th of May 2026, which are subject matter of the present writ petition. And the other development is that after there is a change in the ruling dispensation, now the state government has gone up before the Supreme Court and have withdrawn all the appeals which were pending before the Supreme Court. Therefore, today, my lord, as on today, my lord, nothing is pending before the Supreme Court.
So what is existing today is where the final order of your lordships of 2024 in the first round. The second is below the second round. In the second round, the batch of writ petitions with the interim order is pending today, because since Miller the SLP has been withdrawn, obviously Miller the interim order is subsisting today. And Miller the third would be what Miller I have today come up before your lordships with. Now Miller, in this I mean the recollection of the trail of litigations, Miller, if my lords may now kindly take, Miller, page number 88. Where three notifications are under challenge, where the first one is at page 88. Now, this is notification number 944, dated 18th of May 2026. The governor is hereby pleased to withdraw with immediate effect the following notifications issued by this department, vide numbers 917, 1056, 1057, 1106, and 1107. With these, which were stayed in the second round. Read with the core agenda. But this is Millard 1. The next one, which is Millard, the subject matter of the present petition, is at page 89. Same date, Millard, it is 945, whereas the Honorable Division Bench of the High Court at Calcutta passed a judgment order on 22nd May 2024 in the matter of WPO, etc., wherein the 66 classes included in the state list of OBC prior to 2010 for the purpose of availing reservation under Article 16(4) of the Constitution were not interfered, and distribution of percentage of reservation as 10% for OBC A and 7% for OBC B were struck down. And whereas the Honorable Division Bench of the High Court at Calcutta also limited the reservation for OBCs in the state to 7% for the 66 classes in the state list of OBC unaffected classes. Now, therefore, the governor is pleased to inform accordingly that the state list of OBCs consists of 66 classes to avail 7% reservation in the services and post of the government of West Bengal. Then, Miller, the 66 classes which your lordships were pleased not to touch has been, those classes have been quoted. Then the third one is page number 92. This is the revised 100-point roster, Miller, which was directed. You are requested, Miller, this is an interdepartmental communication. You are requested to revise the current model 100-point roster issued by the Labour Department, vide so and so, in line with the fresh notification referred to in 2, issued by this department in connection with reservation of soils. Now, Miller, these are, Miller, under challenge before my lords. Now, Miller, primarily...
So, Mr. Dotto,
yes, I'm sorry. Miller.
This notification which you are challenging, this has done two things. Brought down the reservation to 7% as per our judgment, and they have published the 66 classes
which were saved.
As we are.
Yes.
Now then, this order appears to be in consonance with our judgment.
Yes. Miller.
Appeal against which has been withdrawn by the system.
Right.
So, Mr. Dotto, at this stage, it is a bit premature because they have not said that we are withdrawing, our policy decision will be this, and we will not be incorporating any other class. That survey has also not started. So at this stage, Mr. Dotto, what interference you call?
May I respectfully respond, Miller? The second notification, in my very respectful submission, was not required at all.
Page 89.
Yes, because without that notification also, whatever your lordships have held is holding the field.
Yes.
So the second notification for that matter is was not at all necessary. But what
to
is
justify their policy decision that we are not going against the judgment. So they issued the notification 66 classes.
Yes, but so far as saving the 66 was never under challenge before the Supreme Court.
No, that we don't know what had been the
Yes,
challenge,
yes.
whether 66.
See, that Miller will demonstrate, Miller.
But at this stage, what
Now, Miller,
intervention
yes.
you want?
First is, so far as the first notification is concerned, which is
880, page 88.
yes. Now, whether Miller, what was the case in the second round? In the second round, Miller, the case was that the procedure which your lordships were pleased to lay down in the first round of litigation has been violated by the state. Therefore, Miller, your lordships were prima facie satisfied with the grievance and your lordships were pleased to stay. State, with the change of ruling dispensation, Miller, my respectful submission is where the Supreme Court has held in innumerable decisions that with the change of political dispensation, you cannot simply sit and review the earlier decisions. Unless, Miller, there is some political involvement in it. Johar Himal and all cases, Miller, the lordships have been at the pleasure to, Miller, go through. Because after all, Miller, this is, Miller, dealing with fundamental rights. Article 15, Article 16 each are, Miller, what is under consideration in this field. Reservation emanates, Miller, vertically from Article 16, horizontally from Article 15. Therefore, Miller, when the state is prescribing for reservation, when the state is demarcating, Miller, OBCs, Miller, it is in fact, Miller, dealing with, Miller, Article 15, 16, read with Article 38 and 39 of the
But that stage has not come, Mr. Dotto.
I'm sorry, Miller.
That stage has not come
Yes,
yet.
that is the stage.
That this notification, if they publish further notification with or with the consent of the commission, then you can say, come and say that this exercise of theirs is derogatory because survey has not been properly conducted, etc., etc. But at this stage, what we will intervene, Mr. Dotto? Because you are saying these notifications referred in page 88, these were stayed by us.
Yes.
Supreme Court stayed our judgment.
Right.
Those things revived.
Right.
Now, who will pursue that case on behalf of the state? State has changed its policy.
Yes. Therefore, Miller, that was also a batch of public interest litigation. Today also, Miller, we are, Miller, before your lordship, in a public interest litigation.
Challenging what? What you are challenging?
May I put it in this way? For the moment, Miller, please, we keep aside, Miller, what has happened on 18th of June. Let us keep aside that. All SLPs have been withdrawn from the Supreme Court, which means that, Miller, the proceedings in the second round, there is no bar on the High Court to go into that veracity of those actions.
That we will consider as and when it is mentioned.
Now,
that challenge is always with you.
That challenge is always there.
The withdrawal of the SLP, our order has revived.
Right.
Now you can, in that matter, it can be argued that there was a correct decision.
But that we cannot argue because today,
but
Miller,
not a party to the same.
Not because of that, because those notifications are not surviving today. The notifications which were stayed, because a stay doesn't mean that your lordship will finally quash it.
No.
Your lordship may uphold that also.
No, Mr. Bhatto, notifications does not survive strictly because this stay has gone. So our stay over the notification is operating. It is only after writ petition was kept pending.
But today the situation is the writ petitions were and are pending. Second round. The interim order passed by your lordships were suspended for some time. Now it is reviving. The interim order is revived, legally speaking.
Now the issue is nobody is being given appointment on the basis of those circulars due to our stay.
Right.
In that you are not a party. That you may say that you cannot urge that issue before us. But when that process starts, that a fresh notification is issued, suppose incorporating upon a purported survey, they issue a notification for inclusion in the schedule which we have struck down. Then the cause of action arises, Mr. Dotto. At this stage, Mr. Dotto, what will you argue? The earlier petition which was moved before us, Mr. Dotto, point was taken that Supreme Court is insisting of the matter. You have gone through that order. In view thereof, primarily in view thereof, we said that we are not interfering. But Supreme Court, while passing that order of withdrawal of appeal, has made it clear that individual rights can always be agitated by filing fresh proceedings. So you can, I think, subject to what you say and what my brother says, that this appears to be a bit premature. Let that notification come, then you come and challenge before us.
Could I say this, my lord? First is, my lord, those notifications which has been withdrawn today, according to us, was in our favor.
Right.
Now, my lord, doing away with this notification definitely affects, my lord, the persons who were declared under those notifications which are challenged in the second round.
State, Mr. Dotto.
No, today it is not surviving.
Yes, we granted a stay in the context of that petition. We are saying in that we granted a stay, as you rightly said, it was suspended due to the Supreme Court. So they have withdrawn the appeal. The writ petition is before us.
Yes. Now the writ petition is before your lordship, challenging a notification which is not surviving. Today those notifications are not surviving.
What are you praying for here, Mr. Dotto?
Lord, here, my lord, if I succeed in demonstrating before your lordships that the 18th May 2026 notifications are bad.
Notifications withdrawing those earlier.
Yes, then the earlier notifications will survive.
No, the earlier notifications issued post 2011 have already been struck down by us.
That is the first round.
Gone.
First round.
Thereafter, the state issued fresh notifications, which we stayed.
Yes.
Went to the Supreme Court. Stayed. Our order stayed.
Right.
Subsequently, SLP is withdrawn. The stay order goes.
Yes.
Our order revives, but in one form, our order also and the writ petitions also become infractors because the state has withdrawn the very basis of those writ petitions.
Right. Yes.
Now, what are you praying for? Your first argument, if we heard you correctly, was a change in political dispensation cannot ipso facto negate an earlier policy decision or earlier administrative order. That is your first argument.
Right.
That will have to be decided. We will decide that after calling for affidavits, if it. What are your other points in this? Please indicate that.
Yes. Well, my first point is well, what I have said. My second point is, we will demonstrate that, in the second round, the notifications that were published in the year 2025 were in tune with, the judgment of your lordships.
Very well. We have certain.
Yes, your lordships may by prima facie.
We will indicate that to you straight away. But please come to your next point.
Yes. Now, prima facie, your lordships were pleased to, come to the conclusion. That is why there was a stay. That no, your lordship's order was not followed in toto. Therefore, these are all prima facie findings. Yes.
We will decide that.
Yes.
We will hear you
Yes.
out. What are you seeking today as an interim measure, if at all?
Yes. Now, interim measure, what I was seeking is, if these notifications are stayed, because there are so many fora, employment, academics, higher education, where people have applied in terms of the prevailing system. Now, what happens to those? Those, I think, calls for, some protection from this court.
Now, Mr. Dotto, coming to the second point that we wanted to answer, as we were just indicating earlier.
Right, my lord.
The primary ground on which we had orally indicated to you may not have found place in the order, if you remember in the arguments there on that day, was this, that the notifications were issued under the Commission Act and not under the 2013 Act.
12 Act. Anyway.
2012 Act.
Yes.
That's now. So the foundational law for issuing notifications, even if they were valid constitutionally, which maybe the current dispensation could not have withdrawn.
Yes, ma'am.
And we are with you on that, assuming we are with you on that. Still, the legal and foundational and fundamental basis, the foundation of those notifications was not there. It wasn't issued under the 2012 Act. They were issued under the
93 Act.
93 Act.
Right.
93 Act does not provide for issuance of any notification for reservation. They were not even issued directly under 16(4) or 16 or whatever it is, which we had said in our judgment that once you have a legislation, you can't fall back on 16. That you can debate, you can argue, because that is our final holding and we are bound by our own judgment.
Right.
That part is okay. Now, when the foundation of the notifications is in question, can you seek any benefit or any benefit derived thereunder? Can it be protected in law? Is what we want to ask you.
But my immediate
For interim protection,
Yes.
Mr. Kindly indicate that.
May the Lordships may kindly have a look to me, Lord, the prayers. But there is a prayer G, my lord.
Yes.
It's a long prayer. Pending disposal, so and so, implementation of the notifications dated such and such of 18/5 and all consequential steps taken and or notification issued pursuant thereto, and direct the respondents to continue treating the members of the affected 74 communities as eligible OBC candidate in terms of the notification issued during the year 25, and further restrain the respondents from denying the reservation benefits, scholarship benefits, welfare benefits, admissions, counseling benefits, recruitment benefits, appointment, or any consequential benefits to the members of the affected communities solely on the basis of the impugned notification, and further restrain the response for publishing, acting, or giving effect to any admission list, counseling list, merit list, selection list, or appointment list to the extent the same prejudicially affects the members of so and so.
That already stands protected because the contempt applications are still pending.
Yes.
But that 74 list which you argued on that day, some appointments allegedly were given or admissions were given. We said in our contempt measure that all things which are being done, we will be considered by us. Contempt is automatically survives again. But Mr. Dotto, how can we, if suppose today you are saying we have to pass an order that you continue to treat those 74 communities as eligible OBC. We have held against that in our parent order, against which appeal has gone. Can we now, being the same division bench, or division bench doesn't matter, same same law which we have tried to lay down, can we today on this petition say that whatever we have said, but you protect the 74%, go on giving protection? This, Mr. Dotto.
May I respectfully submit, my lord? Number one is, my lord, the power of the state is not disputed by the court. The court is of the view that you have exercised power under a statute which is not applicable. But to that, my respectful response would be that even if, my lord, I have quoted a wrong provision, my lord, if the power is ultimately there, my lord, it cannot be faulted on a ground of wrong quotation or provision. This your lordships have held in innumerable
Oh,
judgments.
Mr. This is getting far-fetched. Now, this is far too much. This is where we are having serious difficulty in accepting your argument. We will let affidavits be filed. We will hear it out. We are not inclined to pass an interim order at this stage.
Please give me a
For
moment.
three reasons,
Yes.
at least,
I'm sorry.
we can clear straight away determine. Absence of competence. We said in our parent order, it has to be a legislation, not an executive order. Whereas, what has been done is something which is hybrid. It is brought in the legislature at the instance of the Backward Classes Commission minister or Backward Classes minister. It is tabled. There is the process of passing a legislation means that there is a process of passing a legislation. Then it is sent after the two houses pass it. It is sent to the governor and the governor ratifies it. Then the amendments are to be effected to the schedule of the 2012 Act. That would have been the proper procedure. We would have considered later. It wouldn't have called for interim order had this process been done. We would have considered at a later stage as to whether there was proper survey or not in respect to the new classes. That's a different issue altogether. But here, this hybrid process, whether it constitutes legislation and whether it has complied with our order is the first question. Second thing is, it has not come under the 2012 Act. It has not been under 16. 60, had you done it under 16, it would have been directly falling foul of our parent judgment. Anyway, good, bad, indifferent. Now, that is one part of it. You have declared these classes under the 93 Act. It's like saying, I am declaring these classes under the West Bengal Poultry Development Act. Now, after doing so, you cannot come around and say that, no, I have the legislative competence, executive power. So what if I mention the wrong act? Very difficult to accept, not acceptable. Thirdly, what has happened is this. There is these benefits that you are seeking protection of were granted at a time when the list was pending, both before the High Court as well as the Supreme Court. The Supreme Court did not dismiss the writ petitions. It merely interfered with an interim order. Now, to what extent you could have granted benefits when the matter is being pending before the Supreme Court as well as this court is a big question mark, and we are of this clear view, prima facie, that you could not have granted any benefits to anybody under the notification stayed and partially revived by reason of the order of the Supreme Court. We can either dictate this now, or we can call for affidavits and have a comprehensive hearing.
Time is required, my lord. I understand, my lord.
Which they have not followed.
10 weeks, my lord.
10 weeks is too much. We can review.
They have only withdrawn. They have not
No, but the order is, my lord, subsisting. The order of the division. survives. Really, my lord, very well. 8 weeks, my lord.
Change of government is now what it is. Now it's becoming a vegetable vendor's market.
Yes. Point of maintainability became.
When you don't tell it, the only option available to you is
Upon hearing the learned
Liberty to mention 6 weeks, 4 weeks.
because this is not a regular bench. After it is completed, you come and
Could I make this submission? Since my lordships are heading two different benches, well, with the convenience that your lordships have today, fix a date. But otherwise, I'll mention once before this bench.
After 10 weeks, after the pleadings are complete.
Yes, but after 10, 11 weeks.
To my lord, or mention before my lord, the honorable acting Chief Justice. We will consult and fix a date. Please be rest assured. We want to hear it as soon as possible.
Very good.